Judge, I'll be brief. Just a couple issues on the restitution. We'd like to reserve that.
The entire matter of the $9,700 you stipulate to that amount?
The $2,500 we will stipulate to. There's a $7,500 amount that we would like to reserve.
All right, and put that in my notes. All right, please continue. Thank you.
Just to know also that she has served 316 days in custody, and she should be given credit for that. Addressing Mr. Brown's remarks about aggravating mitigating circumstances, I do take exception to that. The offense, I believe, and he can correct me if I missed this, but I believe he wanted the court to take note of the offense caused the death. While that is true, that is contemplated in the charge itself, which would would comprise this of sort of a double dipping. I think that's what the guidelines set out to exclude. Also, the offense involved 2 or more victims. While I will absolutely not discount the family members and their pain and heartache through what happened here in this case, in that sense, they are absolutely victims. But I think for these purposes, they would not technically be victims of this offense. It would be Matt alone. Otherwise, I couldn't think of a criminal offense in the Utah Code where we could not expand that definition. So I don't think that should count either. As for mitigating circumstances, I'll get into the details of this, but I would like the court to note as an other her cooperation with law enforcement. I think that's significant. There's probably nothing that Ms. Restelli could say today that is going to help the Restelli family deal with this loss, deal with the pain that they've endured caused by Kathryn. And there's certainly nothing that I could say that would lessen their pain as well. So I only hope that after hearing what they have said today, that they could possibly at some point in their lives have some peace and perhaps even forgiveness at some point, so they can move on for themselves, but also put the pain aside in their lives. And I do want to, I guess the only other thing that I can really add that is my unique perspective is my interaction with Kathryn during the pendency of this case. At no time was she gloating, at no time was she happy, at no time was she content, at no time was she anything other than distraught, sad, and reflective of the pain that she has caused. Many times in the criminal justice process, we have negotiations, cases go back and forth, we talk about resolving, and that was never actually a topic that we broached collectively because of the nature of the offense. It was Kathryn who brought it up to me. Kathryn wanted resolution. Kathryn wanted to bring some modicum of peace, to bring the truth to light. It may seem hollow at this point after she had been arrested and was in custody and was facing various very serious charges. But I don't think that should discount her motives, because she didn't have to come forward the way she did. But she felt the weight of what had happened and her responsibility on that. And as her attorney, she asked me to go forward to the state to say she wanted to participate. and she wanted to help. I think the state has acknowledged that that was the case. We initiated contact to let them know that she would be fully willing to cooperate, to help bring full closure to this case in some sort, hopefully, and to the Restelli family. Obviously, there are still some unknowns with trials pending, but for Kathryn's part, she cooperated with law enforcement and fully intends to cooperate at trial to make sure that she can make amends, can make some sort of restitution from her part for her part in what has happened here. And I think that's significant, particularly considering what she pled to. And yes, it is a reduction. However, she does have a life top over her. I know the Restelli family, it sounds like they're probably going to be appearing at board hearings, and that's going to have an impact. It's hard to really tell how much time she's going to serve, but it will be substantial, regardless of this plea agreement. And it should not go unnoticed that her actions are also hurting her family. Her willingness to participate in the prosecution, to potentially testify against her brother and her mother, people that she loved, is difficult. And in some sense, I think extraordinary. And that should be accounted for. Sometimes people may testify against other people who are their friends, who may have some connection, but not familial. I think this is a rare occasion. But she's doing so because she thinks it's the right thing, and I agree that it's the right thing for her to do. And I know Kathryn does have a brief statement that she wants to make. The last thing I will say is, just as I noted before, my experience with her is she has seen the pain that she has caused. To fully understand the scope of it may take time. And she hopes that someday the family will be able to forgive her, because she won't be able to have contact with her children unless they agree to it. And at some point, at some time, she hopes to be able to manifest to the family that she is sorrowful, she is remorseful, she is penitent for what she did in this case. But understanding also it may take many years for everybody to accept any sort of an apology or receive some type of forgiveness in this. But in light of all the circumstances, Judge, along with Mr. Brown, I believe is my understanding that the family in this case, the state, all the parties have mutually agreed on the plea agreement, which is why we think it is appropriate. We'll ask the court to follow that.
Before you stop, I want to make sure I got the right time frame. You're saying she served 316 days today?
Correct.
Mr. Brown, do you concur?
I haven't run the math, or I can do that right now.
That's what's reported in the pre-sentence report.
I saw that, but then I thought
Yeah.
maybe you had a different number there. Okay, all right, thank you.
I'm sure the board will calculate it regardless, but if the court
I'll
wants to
give
make that
credit
known.
for time served, which
Right.
we believe to be 316.
Correct.
All right.
I'm so very deeply sorry for the pain that I've caused. I understand that my apology will never be enough to heal the hurt that Matt's death has caused and continues to cause. He didn't deserve it. If I had the power to bring him back, I would. I know that my actions directly caused Matt's death. And for my part, I realized the devastation I caused. I didn't think about the pain it would cause. My heart breaks for his children, his family, his friends, and his community. At this point, the least I could do is speak the truth on what happened to give Matt and his family the justice they deserve.
Anything else, Mr. Brown?
That's it, Judge.
Anything else from the state? That should be one. All right, thank you. In taking notes of the information I received today, I read all the letters that were submitted to the court from both sides prior to court today. I've fully studied out the statement in advance of plea. I also went over my notes from the preliminary hearings in this matter to make sure my memory was correct.
In your Honor, just briefly, I apologize, we would be asking for a continuous protective order.
I've already got that in my notes.
Perfect.
All right, thank you. The court cannot add to what was said by Mr. Restelli's family members today to describe the type of person that he clearly was. As time passes, I hope that his family will be able to only recall the good memories that you have of him, and that you'll be able to put behind you the tragic events of July of 2024. I'm sure that will take time, but I hope that can occur. Ms. Restelli, what struck me in the numerous statements in your letters of support that I received was that you quote-unquote loved your children. That's simply not true. Your selfish actions show that you didn't love your children at all. You made them victims. And let me be clear, your children are victims of your actions. They'll be lifetime victims of your actions, and they deserve to grow up without you in their lives. Your actions the day after the events of July show how callous and uncaring you were towards your children and what you did to their father. You tell me in your statement in advance of plea or your pre-sentence report that you wanted to back out of the plan to kill your husband. Yet hours after their father was killed, you were preparing for a date, according to a friend of yours from this court. And you were showing off the scene of a crime to those friends like it was a trophy. When you received condolences from a friend of yours from Discord, you said, quote, "It's okay, I'm happy." I simply do not find it all credible your claim that you wanted to back out of the plan to kill your husband after 5 p.m. on the events of July 2024. As Mr. Brown pointed out, the record is clear and unambiguous. You still had ongoing telephonic communications with your husband before the events that led to his death that night. But more importantly, you had more than just hours to do something about that. You had days to stop your family's plan to kill your husband. But you elected not to do anything. It's clear to the court that your statements and actions or lack thereof in July 2024 was not of somebody who wanted to back out of the plan that you admitted to in your statement in advance of plea, but of somebody who was willing to go forward with it and was happy that the event and the plan was successful. I think it's also important to remind you, as the state pointed out, that you had also entered into a plea deal regarding domestic violence, physical domestic violence against Matt. And there's no record that he ever committed any domestic violence against you. Indeed, it struck the court in our preliminary hearings that you repeatedly told a divorce attorney in the state of Utah that he never physically abused you. So you're not a victim, you're the perpetrator of incredible harm of domestic violence to your children and, of course, to your husband. With those brief facts in mind, I'm going to proceed for sentencing. I'm going to order restitution. There's a stipulation to $2,500 at this time. Further restitution is to remain open as allowed by statute. It's required by state law. I'm going to order a $53 court security fee for each count. Fines and fees will be sent to the Office of State Debt Collection. I will waive the fine in this matter. Any assets that you have should go to your children for their support and the restitution for them. I am going to enter a continuous protective order. That means you can have no contact with your children directly or indirectly. And if you violate that, new felony charges can be brought against you. And by statute, the presumption is that they would run consecutive to your current sentence. As allowed by statute and as required, I will give you credit for time served, which the parties believe is 316 days at this time. I do note that both the state and your attorney have discussed that your offer is based upon your willingness to cooperate with law enforcement. That was reflected in the plea deal that was offered you, which included the stipulated sentence. That doesn't, however, change what you did and how you did it, or what you did during July of 2024 to your husband. For the family, I do need to point out that we have an indeterminate sentencing system in the state of Utah. I imposed a range, and the Utah State Parole Board will ultimately decide how much time Ms. Restelli will serve in prison. As to count 1, murder, a second-degree felony, I impose a statutory maximum of 1 to 15 years in the Utah State Prison. As to count 2, conspiracy to commit murder, domestic violence, also a second-degree felony, I impose the statutory maximum allowed by state law, 1 to 15 years in the Utah State Prison. As to count 3, felony discharge of a firearm, domestic violence, a first-degree felony, I impose the statutory maximum, according to state law, of 5 years to life in prison. Counts 1 and 3 will run consecutive to each other. By stipulation, count 2 will run concurrent. Do note, Ms. Restelli, you have 30 days to appeal the sentence. On an appeal, if you qualify and request the same, an attorney will be appointed to represent you. Any questions from the state?
No, thank you.
Any questions from the defense?
None.
All right, thank you, ladies and gentlemen. This court will be in recess.
Thank you.
All rise. Thank you. You may be seated.